let us. Okay, so are you able to see the screen?
Yes, sir. Yes, sir.
Public interest litigation. So public interest litigation, this is basically the main thing is it is there is no specific law. It is developed by the judiciary itself. See, in any case, there is a thing called the person, okay, who is not interested in the case, he cannot file. Okay, third party cannot file in any case. So public interest litigation is only exception for that. Even if you are not in that locus standi, what we call is locus standi. So if you are not involved, there is not, it is not affecting you, you cannot file a case. Especially it is civil case, lot sort of thing, only public interest litigation. So civil cases, only private person or tort cases where private person whose rights are affected, he can file. Third person cannot file. But in public interest litigation, any third person can file. That is, even though there is no locus standi. What is that? Locus standi. That is very important word. So if there is no locus standi also, you can file public interest litigation. So it is action initiated in court of law for the enforcement of public interest or general welfare. So you cannot see, you get questions where I filed a case for road for my house. No, it is, you cannot file, courts will dismiss. So it should be for public interest, not private interest. They will ask this question. There was a question last year or before year, private interest and public interest. So public interest litigation is filed only in the public interest, general welfare, okay, where party filing the petition may not have been personally injured or aggrieved. This is very important.
So sorry to disturb you. Now you said, no, for example, it is for all road. If there is no road, someone file a PIL, then it is interest. He is also beneficiary, no? Then in that
he is
case,
also beneficiary. He is also beneficiary, but benefit should go for the public at large. So road to his house is not important. Road to his village is important.
Yeah, that means it's allowed.
Yes.
Okay, sir.
Okay. So it is non-adversarial. They call it public interest litigation is also called non-adversarial. Okay. It is not targeting any specific individual. So it is purely for public advantage, public benefit. You are doing something good for the public. You are filing public interest litigation. It is not targeting any specific individual, like any law that you are getting benefit, you are trying to punish somebody, all those things. So it is nothing to do this. Okay. So first reported case is Husainara Khatun. 1979 is first, I think I have given that. So it is basically evolved. It is called judicial activism also. Judicial, part of judicial review. It is linked to judicial review. You can go through this. I think I shared this presentation in the group yesterday. So it is part of judicial activism because judiciary, they have taken on themselves to allow these such petitions. So there was challenge in earlier stages when pills were not allowed, but judiciary specifically focused that we can take these cases even though there is no locus standi. Okay. So traditional rule violated, that locus standi is not there. Traditional rule is locus standi should be there. Your personal injury should be there. Okay. Epistolary jurisdiction. So a simple letter, postcard also, court themselves they can take. There is need not of a formal writ petition. Any simple letter can also help. If you are uneducated, you can put your presentation small letter, ask somebody to write a letter. Court can take it as on its own, suo motu. They can start. So lot of things are relaxed for the locus standi. So Article 32, Article 226, you can file this thing, pills. If it is in Supreme Court, it is Article 32. If it is in High Court, it is Article 226. Writs will be filed under these articles. And who is called father of PIL is Justice P.N. Bhagavati. Okay. So, but basically, Krishna here also evolved a lot of things, but a lot of credit went to P.N. Bhagavati because a lot of cases, he is the one who started dealing initially. So, P.N. Bhagavati, Justice P.N. Bhagavati is the one who is also called father of you may get this question, but basically this is started by PN Bhagavati only. If there is any option between PN Bhagavati and Krishna Iyer, you choose PN Bhagavati. If only PN Bhagavati is there, choose PN Bhagavati. And if PN Bhagavati is not there, Krishna Iyer is there, you can choose Krishna Iyer also. But if PN Bhagavati is there, you have to choose PN Bhagavati only. So this is the first reported case. I mean, reported case. There may be one or two unreported cases, but when we are talking of public interest litigation, Hussainara Cartoon versus State of Bihar, 1979, where conditions of under trial prisoners, it is taken under this case, where I mean there were under trial where whose, let us say, punishment is for 3 years, but they are in jail for the last 4 or 5 years. So speedy trial. Also, you get this case law Hussainara Cartoon. This is also part of PIL. It is also for speedy trial. Okay.
It is only applicable for criminal cases only, no, sir, not civil.
No, it is only for criminal cases. Okay, because they were in jail. So who were in jail, I told, right?
That's
So Hussainara Cartoon is for that first legal aid also, no, sir? First legal aid.
Yes.
Oh, correct. Thank you, sir. Thank you.
Okay, so that is basically SP Gupta. See, you find lot of cases by SP Gupta. So he filed lot of petitions. So one of that such petition is transfer of judiciary, arbitrary transfers, all those things. Judge transfer cases is one of the thing. SP Gupta versus Union of India. Okay, so this is frivolous and private interest litigation. This you get questions. Ban on personal vendetta on because of you are having some grudge against somebody to gain personal advantage or private malice, settling disputes between two parties. You file a case. That is public interest litigation with personal vendetta is not thing. Imposition of costs, exemplary costs are imposed. Yesterday they dismissed the case by one advocate, ex-judge. I don't remember his name. He filed a case against government. Andhra Pradesh government passed. I see we get a lot of cases in Andhra Pradesh only. They do a lot of such things. Okay, one advocate filed a case against Satya Sai. Government declared some specific day or whatever. I don't remember exactly, but just it was there on headlines. I keep on going through headlines in some when we sit in the court. Headlines will be there. People, because I cannot change the channel. So whatever channel they keep, we have to watch those things in High Court or other courts. So TV9, TV5, they watch only news. So there will be headlines. So that Shravan, Jada Shravan, I remember that name. So he filed a case against Satya Sai some occasion. So High Court dismissed that one. Okay, they cannot take some frivolous cases or personal related issues. So he may be having some issues, and there are other things also important, but just I'm giving example. So they impose cost or they dismiss such cases. So you can take socio-economic cases, a lot of bonded labor cases, child labor cases, minimum wages cases are there. In case laws, you can go through that. Free legal aid cases are there. Okay, rights of women, sexual harassment, that is Vishaka case is there. So those are public interest. Environmental cases, MC Mehta, a lot of MC Mehta cases, as I told. Corruption in public offices, protection of historical mood, that is Taj corridor case, that is also part of public interest litigation. So all these cases, most of the cases, I think MC Mehta filed around 10 to 15 very popular, high popular cases. He's an advocate, Supreme Court advocate. He filed those cases actually. So MC Mehta is not an individual. He's an advocate. He keeps on filing a lot of environmental related cases, and he became popular because of that one. Everyone know MC Mehta. Okay. So he filed a lot of such cases. And let me tell you one thing, a lot of his cases are dismissed. Okay, so he files nuisance cases also. So don't take that he files all good cases. So PIL is the tool for judicial activism, broadening the scope of Article 21, that is right to life, including rights to dignity, health, environment, speedy justice. This is basically Article 21. You should remember most of the PILs are related to article that is right to life. That is your dignity, your health, your environment. Your environment is part of right to life only. Then speedy justice. This is also part of personal rights, right? Okay. So key test: does the petition address the genuinely public injury or wrong? This is the key test for any public interest litigation. So this is the thing, my friends. So we'll end. If you are having any doubts, you can post it in the group. I had to rush because